We'll go ahead and turn the class over to Ed. And Ed, thank you so much again for joining us. We truly are very appreciative to have you.
Stephanie, you're very welcome. Always fun to volunteer and help out the Arcadia Association. All right, so I'm going to go ahead and share my screen. I will be checking the chat as we go through. Typically, I like to share the chat at the end of each page. That's always kind of a good stopping point. And then when we get to the end, I'll go back into the chat. I'll stay around for questions. So if you don't get a question in, or sometimes I might have to skip over a question because it's getting a little too complicated, or maybe it's a little too personal, I can do that. So again, I never end a class without making sure that all questions are answered. At the end, I do have my contact information, so you can see that. If you want a copy of this PowerPoint handout, you can certainly email me. My email is at the end of this screen, estes@mountsac.edu. So you can copy it down there. So that'll be nice and easy. The only thing I want to stress, I'm not here to give legal advice. So even though I am an attorney, in addition to being a real estate broker, this is just for educational purposes. I no longer practice law. I teach full-time at Mount San Antonio College. All right, so let's go and let me set up the little PowerPoint and let me minimize all of you so I don't get distracted looking at you and not at my PowerPoint. So all of you should see the title page, and we'll go to page 1. And what I like to do here is break it down and do it section by section. So as we go into the agreement, you'll see at the very top, there's a place for date prepared. Doesn't really matter what date you put up there, because all of your timeframes go from the date of signature or the date of acceptance. The only reason to put a date here is to give this agreement a name. So if you want to do an addendum or an amendment, or you're going to counter offer, you'll be counter offering the purchase agreement dated November 13, 2020, right? So again, that's why we put a date on there, to actually give it a name. Now, be sure to put in all the names of your buyers. If you're planning on adding more buyers and you know who they are, go ahead and put them in. If you are not sure, if you're thinking of adding people, in paragraph 26 of this agreement, and don't go ahead and try to look it up. Trust me, it's there. We'll get to it. In paragraph 26, it says that you cannot assign this agreement without permission of the seller. So if you do want to add additional buyers later, or you think you might, what you need to do is put in the names of the buyers you know, and then put in the words and or assignee. And then when we get to paragraph 6, which is the other terms paragraph, you would type in there or write in there, paragraph 26 is deleted from this agreement. Okay, so the deal is this agreement cannot be assigned without permission of the seller. So if you want to add an assignee, you put the name and or assignee there in line 1A. When we get down to paragraph 6, you're going to type in paragraph 26 is deleted, and paragraph 26 is the paragraph that prohibits assignments, right? So again, we never want to cross things out in an agreement, because if you start crossing things out, invariably you'll cross too much or not enough. It's just better to delete paragraphs or add addenda, right? All right, so then in B, we are going to describe the property. So we will typically put a common address, 1234 Easy Street, right? City of Arcadia, County Los Angeles, zip code 9 whatever. I don't know what the zip code is in Arcadia. You also have a place for assessor parcel number. You're not required to put that in, but it's a good way to add a second identification of the property. If you're ever writing an offer on vacant land, and of course we do have the vacant land purchase agreement, vacant pieces of land probably don't have street addresses. As a matter of fact, vacant land may not even have a street, right? You can identify a property for the purposes of a purchase agreement with just an assessor parcel number. The APN is unique to a property within a county. So as long as you identify the county and the state and the APN, that's good enough. Just another thing for thought, by looking up the APN, the assessor parcel number, you do that through Realist inside your MLS, right? It forces you to see who the purported owner is, or at least for tax purposes, of the property. So if you get a counteroffer from somebody else, you can try and find out who that person is. True story. I had an agent working for me years ago, wrote an offer, got a counteroffer back, didn't recognize the name on the counteroffer because it didn't match up with the tax rolls. Asked the listing agent, who is this person? Well, the listing agent thought it was the owner of the property. Wrong. It was the tenant of the owner of the property. The tenant thought they could list the property and sell it without the owner finding out. Now, we're in the real estate business. We realize how ridiculous that is, but imagine how embarrassed that listing agent was that they had listed the property with the tenant. Okay, so just FYI, when you go out on a listing appointment, it doesn't hurt to look at the tax rolls to make sure that the person you're talking to is the purported owner. Okay, so purchase price, you want to put it in both alphabetic and numerical form. Of course, if you just type in the numerical form to the right of dollars and that dollar sign, it will automatically spell out. So just as you would a check, you want to put it in both alphabetic form and numerical form. And then under D are close of escrow. So you have a choice here. You can either put in a specific date or you can do days after acceptance. So let's say hypothetically I was going to put in January 5th or January 6th. So you would be thinking, what? This is probably going to be about a 45-day escrow, right? Well, the problem with trying to write 45-day escrow to the right of that is you don't know when escrow will actually close. And this is why I don't like writing in a specific date. So let's say I do January 5th. So my buyers are thinking about a 45-day escrow. Well, conceivably, we could have 2 or 3 counter offers, and we may not get an acceptance until the end of the month, particularly with Thanksgiving coming up. Well, what happened to my 45-day escrow? We're still supposed to close on January 5th. My 45-day escrow is now turned into a 30-day escrow, and maybe my parties can't perform in 30 days. So you do not, in my opinion, want to fill in a specific date. You want to go with the or, check the box, and just write in 45 days or 60 days or 30 days or whatever time period you want. The days will run from the time of acceptance. Now, if for some reason you have to close by the end of the year, or you're coming out of a 1031 tax deferred exchange, and you really need to put in a specific date, you certainly can. Just remember, you don't do both. It's one or the other, right? One or the other, because you'll never match the two up, right? Because you don't know when you're going to get your actual acceptance. Now, we go into agency. All of you are familiar with agency disclosure. You must give that AD form, that agency disclosure form, to the buyer prior to drafting this agreement. My recommendation is to give that agency disclosure form to your buyer before you start showing them property. And here's why. The law states that you cannot claim a party, a buyer, as your client until after you disclose agency to them. And if you haven't disclosed agency to them, they're not your buyer. So can you claim somebody stole your buyer? No, because they're not your buyer. Another true story. When I was managing a large office in San Diego, got a call in the morning, very upset agent from a different company, threatening to sue us, take us before the ethics board because one of our agents had stolen his buyer. So I said, let me talk to my agent and I'll call you back. So I called up the agent in our office, and yes, she had written an offer the day before on Sunday afternoon. on a listing of hers that she was holding open a house. So she double-ended the deal. She sold her own listing to this buyer. And she told me, he came in, I asked him, are you working with another agent? And he said, I have seen properties by other agents, but I do not have an agent. I am not working with an agent. So I took that information. I called this other agent back. Now, of course, this is not a phone call I was really looking forward to, but I called him back and I said, our agent has a different understanding of what happened than you do. Do you have a buyer broker agreement? That buyer representation agreement? I actually teach the class here at Arcadia, all right? Do you have that agreement signed with your buyer? And he says, no, and I don't need one. I'm still going to sue you. Okay. So I went to, do you have or can you send me a copy of the agency disclosure agreement, or agency disclosure form? It's not an agreement. The agency disclosure form that you have with the buyer. And he says, I don't have one. And of course, I knew he didn't have one because when do you guys use that AD form? Right before you write the offer, which is the absolute last opportunity you can have that thing signed and still be within the law. Well, he didn't have one signed. So I told him, you lose. You lose because Civil Code 2079.14 states that not only are you required to have an agency disclosure before you can claim a buyer as your client, the penalty for not doing it is loss of commission, and you lose again, right? So if you can take one thing away from this class, make sure you get that AD form signed before you start showing buyer's property. All right, so we've already made our disclosure and we're now ready for the confirmation. So you'll notice we have seller's brokerage firm and buyer's brokerage firm. And of course, you're writing this for the buyer. So you are the buyer's brokerage firm. You will write in your brokerage firm's name, Century 21, XYZ Realty, Keller Williams, YZ Realty, whatever. Okay, you write that name in there and then state whether your company is single or dual agency. Is your brokerage only representing the buyer? Or are you writing an offer on somebody's listing in your office, which means you'll be going with buyer and seller as dual agent? And below that, where it says buyer's agent, you will write your name in, and then you will check the corresponding box the same as you did above. So if your broker is in single agency, you are in single agency. But if your broker is representing buyer and seller, in other words, you're writing an offer on somebody's listing in your office, then you have to be a dual agent as well. So whatever you put down for a brokerage firm, either buyer or both buyer and seller, you will have to do the same to you. You are either buyer or buyer and seller. Okay, so whatever your broker is, you have to be as well. Now, the last line there, C, potentially competing buyers and sellers. This is the PRBS form. The big importance of the PRBS form is it says that if you have to go into dual agency because your buyer wants to write an offer on one of your company's listings, your buyer agrees to that. So when do you need to get this PRBS form signed? Right after the agency disclosure form is signed. So you meet the buyer in your office. The first form you give them is that AD form that we talked about up in 2A. And then right after they sign that, you give them the PRBS form that you see in 2C and have them sign that. Because you do not want to get ready to write an offer and have your buyer tell you that they had read something on the internet that they should never go into dual agency, that they should stay in single agency, and then they refuse to go along with the agency confirmation because now you've lost your buyer, right? Because you have to go into dual agency because your brokerage firm is already representing the seller. And the way you avoid that is by having that PRBS signed, and you need to have it signed before you start showing buyers' properties. Now, remember, You have to get the AD form signed anyway. It's the law. You have to get the PRBS form signed anyway, because it's in the contract and your broker is not going to let you have your commission unless that file is complete, which means that PRBS has to be done. So please don't get that PRBS signed in escrow, which I know a lot of agents do, because it doesn't give you any protection. If you're going to get a form done, you might as well get it done where it helps you, right? Okay, so the second thing to take away from this class, make sure that PRBS is signed before you start showing buyers' properties. All right, so now let's go into paragraph 3, finance terms. And our first thing to put in is the initial deposit. And a lot of new agents always ask me, how much should the deposit be? Well, the easy answer is it doesn't matter. It's not even legally required. It's certainly expected. Don't expect a seller to accept your offer if you're not coming in with a deposit, but it's not legally required, all right? It shows simply good faith. Remember, Shenlin, maybe mute your mic. Thank you. It just shows good faith. And of course, the larger the deposit, the more good faith. So you want to have your buyer come in with as large of a deposit as possible, because it's certainly going to make your offer look better. But I don't recommend you go over $10,000. And here's why. $10,000 is the limit in small claims court currently. All right. If you go over $10,000 and there's a dispute in escrow and one of the parties wants to cancel, the other party doesn't want to give up their deposit, right? Run into those situations. Then you're going to have to hire a lawyer and go into superior court. And that could take 2, 3, maybe longer years, okay? So you might be looking at 3 or 4 years to try to get that deposit back. But if it's for $10,000 or less, you go into small claims court, and in a non-COVID environment, you should be in and out in what, 45 days, right? So I recommend the deposit be at or less than $10,000. Now, I know some of you are going to have a response that, you know, I have very expensive listings. I have really nice homes and I want more deposit. Okay. If you have a situation where the deposit is going to go over 10,000, then I recommend you include the arbitration clause. And here's why. If you have a buyer or a seller, if you have a seller who has a house that deserves a large deposit because it's such a nice home, say what, up in Bradbury, right? If you have a buyer that can afford to pay that kind of price and qualify for that loan, then you probably have pretty sophisticated buyers and sellers. So in arbitration, you sit around a table with the arbitrator and explain your case, call your witnesses, present your evidence, cross-examine the other party's witnesses. Could a sophisticated buyer or seller go into arbitration on their own without an attorney? Yeah, I think they could. Now, they can bring in an attorney if they want to, but they may not need to. And you can be through an arbitration in about maybe 45, 60 days. You don't have to go into superior court. So my first recommendation on the deposit, $10,000 or less. If you're going to go above that, parties should consider including the arbitration clause. All right, now the default language of 3A says that the buyer will deliver to escrow by electronic funds the deposit within 3 business days. So you don't have to check anything under 3A if you're good with that. And hopefully you're good with that, because if you accept the deposit, you're in receipt of trust funds. Your broker's not going to be very happy with you because it creates more liability. You're not going to be very happy with you because it takes more work. So let's just have the buyer deliver the deposit to escrow by electronic funds within 3 business days, which is what the contract says. Now, I know there are some dinosaur agents out there that still want a copy of the deposit check. You're just going to have to nicely explain to them that this contract was changed a little over, 10 years ago, and buyers now deliver the deposit directly to escrow. You don't come in receipt of those deposits anymore. Now, if your buyer is tech phobic, you can check the box that says that the buyer will deliver the deposit to escrow with a personal check. But again, don't even make a copy of that check, because if you make a photocopy of that check, you're in receipt of trust funds. Because once you put that check in your hands or in the photocopy machine, your brokerage is in receipt of trust funds, and you have to log that in and log that out. So don't even make a copy of it, all right? You're just asking for problems. How many of us have forgotten something in the photocopier, right? That would be conversion, all right? So you don't want to go there. Just have the buyer deliver the deposit directly to escrow and you're good. Now, if you want to receive the deposit check and take receipt of trust funds, then you would check 3A2. I don't recommend that. And I'm willing to guess most of your brokers and managers prohibit that. All right. So again, let's go with 3A1, simpler, easier, less liability, less work for you. Now, 3B is another problem, and that's the increase of deposit. So if the buyer increases their deposit in escrow after acceptance, in order for that increase of deposit to be applicable to liquidated damages, if you've initialed the liquidated damages clause, or should I say, if your buyer and seller have initialed the liquidated damages clause, then you have to give them the RID form, or receipt for increase of deposit. And of course, invariably, they bring that increase of deposit to escrow. You're not there to give them the RID form, and you're just creating more liability for yourself. So my recommendation is leave B alone. Don't put anything in B. Have your buyer come in with their maximum deposit for 3A, skip over 3B, and move on down to C. Now, C is for all cash offers. So if you have a buyer that has an all cash offer, you would check the C box, and then you would also attach to this offer proof of those funds. So perhaps a bank statement showing they have the money, or a stock brokerage account statement showing they have the money to pay all cash. If they don't have that as you're writing the offer, then you have to check that second box under C just above D where it says loans. And that means the buyer will have 3 days to deliver that verification. Now get into D, loans. Now, I know there's a lot of agents out there that don't like filling out the loan information. I'm here to tell you it will, first of all, make your offer look stronger, because it looks like you really have qualified your buyer. And secondly, it can actually give protection to your buyer, because under D1, you're going to put in the interest rate and the amount of points that this loan is going to do. I once had an agent who didn't fill this out, presented an offer on one of my listings, and I asked them why they didn't fill out D, and they told me, well, we don't know what kind of loan we're going to get yet. And I looked at the agent and I said, then how in the world did your lender come up with this pre-approval letter, right? So again, you don't have to worry about filling this out. Your lender will do it for you. They will tell you what to put in. And you should always have a pre-qualification or pre-approval letter accompanying your offers anyway, because again, it shows that you've done due diligence on behalf of your buyer to make sure they can get the loan they're looking for. This paragraph says it's going to be conventional financing. If you're going with a government, then you need to check whether it's FHA or VA. I would consider it to be a material misrepresentation to go in with an offer without checking the FHA or VA box, only to later have your buyer say, we're doing FHA or VA. All right. That would be a material misrepresentation, possibly even fraud. So again, I know it's harder to get an FHA or a VA offer accepted, but if you're going FHA or VA with your buyer, you've got to disclose that to the seller with the offer. Otherwise, you are making a material misrepresentation because the offer says conventional financing. If you have a second loan under D2, you do the same thing that you did for D1. Now, remember earlier I said this paragraph can actually protect your buyer? Let me explain that. Let's say, and I don't know what rates are right now, but let's say they're 3.5%. So I write this offer at 3.5 or 3.75%. And let's say then because of COVID, and because Donald Trump does something crazy before he leaves office, or who knows what, the markets collapse, right? And now there's no financing available. Shinlin, your mic is on. Would you please shut your mic off? Thank you. And those loans aren't available. You can't get that loan anymore. And of course, the buyer has already released their contingencies and the liquidated damages clause is initialed, and they're now looking at losing their deposit. I think your buyer has a very strong argument before a small claims court judge to say, Your Honor, when we wrote this offer, this is what market rates were. What happened in the market was completely unforeseen. It would be unfair to allow the buyer to lose their deposit. And I think a small claims court judge would buy that. So not only does it make your offer look better to the seller, it can also protect your buyer. And that is your job, to protect your buyer. Now, if you do have an FHA or VA situation, paragraph D3 comes into play. That means that within 17 days from acceptance, you'll have to give the FVA form to the seller. The FVA form states to the seller what additional closing costs and or repairs they have to do. So it basically works like a cost of repairs. The form says that the lender requires and the buyer requests the seller make the following repairs, or in the case of VA, the lender requires and the buyer requests that the seller pay the following closing costs. You're not going to know what those are until after the appraiser completes their appraisal on the property. If that is unfamiliar to you, then you have not done too many FHA or VA transactions, which is fine because I get a lot of new people in this class because we're talking about the contract. What you need to do is sit down with your lender. If your lender is not experienced with FHA or VA, then talk to somebody in your office and reach out to a lender who is familiar with FHA and VA. They can sit down with you in about 30 minutes or so, explain the basic fundamentals of how an FHA loan works and how a VA loan works. The bottom line is there's more red tape, it takes longer, and it typically costs the seller money, which is why sellers are not real excited about FHA and VA offers. But, we deal with the buyer we have, and when you have a ready, able, willing buyer, you represent them to the best of your ability. And sometimes that means writing an FHA or VA offer. Now, E is for additional financing terms. So if you do have anything you want to put in there, what a lot of agents will use this area for is if you're going to ask the seller to pay for closing costs or some of the closing costs for the buyer, you might write in there, seller to pay closing costs of the buyer not to exceed $6,000 or $8,000 or whatever it might be. You can put that in there. F for the balance of your down payment, and G is your total purchase price. Now, if you're using zip forms and you just start typing in the numbers on the right-hand side, it will automatically add up for F and G. Those are autofill. So it's real easy. All you do is put in the deposit, put in the loan amount. It'll actually write in or fill in F and G for you. Couldn't be simpler. Math is always correct. But if you're filling out this form in the field, and I do recommend that agents keep an extra copy of the purchase agreement in their folder, in their real estate box in the trunk of your car. If you don't have a real estate box in the trunk of your car, next time you're at Costco, go or Home Depot, pick up one of those milky white plastic boxes, the kind with the attached interlocking lid. You know what I'm talking about, right? That's going to be your real estate box. Put all your real estate materials in there. That way, if you ever have to get your car serviced and they give you a loaner car, you just go to your truck, get your real estate box, and you have everything in there. You've got your business cards, you've got extra forms, you've got a tape measure, you've got a battery charger, all the things you need, right? Have it right there in your real estate box. Okay, so you have an extra copy of these forms in your real estate box. CAR won't let you print this form out unless you put something in the name of the buyer, right? So what I do is I use the underline key. Just use the underline key, and Zip Forms doesn't know whether that's a person's name or an underline. So that's a good way that you can use and print out some blank forms, all right? But if you're out in the field and you're filling out this contract, this is how you have to do it. Under 3A, you write down your deposit. Under 3D, you write down the loan amount. And under 3G, you write down the purchase price. It is the purchase price, or G, minus the loan, which is D, minus the deposit, which is A, equals F. I'll say that again for you. G minus D minus A equals F. One more time. G minus D minus A equals F, right? It's the only way you can do it, okay? It's the only way you can do it, because your loan is going to be a percentage of the purchase price, which is G. So you put in the deposit, the loan amount, and G, and then you take G minus D minus A, and that will give you F, okay? But again, after you write your numbers in, go back with your calculator and take A plus D plus F equals G. If it doesn't add up right, you better fix it, because nothing is going to shoot your credibility down to a listing agent if your numbers don't add up. And I've seen countless offers where the numbers did not add up. One other thing, if you've got a VA buyer, remember that's 100% financing. So F is going to be a negative number, because it's going to be the deposit amount coming back to the buyer, because the loan is 100% of the purchase price. I know a lot of agents, when they see a negative number for the first time in F, it scares them. Just think of it as an accounting tool, right? It has to be a negative number because the deposit has to come back to F, because D, your loan amount, is going to be the same as G, your purchase price, because the beauty of the beauty of a VA is 100% finance. All right. Now, that is the end of the first page, and I don't see anything in the chat. So I either did a really good job of explaining the contract, or you guys are sleeping. Hopefully you're not sleeping. All right, so we're going to go ahead and move on, but we will come back and take questions later on any page if you want to. All right, so now we're going to go into page 2. And we start out with H, verification of down payment and closing costs. So the buyer has 3 days to verify to the seller that they have the down payment and closing costs. That can be a letter from their bank, or it can be a copy of their bank statement showing that the money is there. Now, typically, sellers want what we call seasoned funds. They want to see that the money's been there for the last 2 or 3 months. The old saying is, if the money showed up 2 weeks ago, it's a loan. If the money's been there for 3 months, it really is your money, right? All right. Or if you check the box in H, that means you've attached the verification, which again makes your offer look stronger. Now, the next paragraph, 3I, is the appraisal contingency. An appraisal is always a contingency of the offer unless you check that box in the parentheses that says it's not contingent, all right? So appraisal is always a contingency. Now, this could come as a hiccup if you've got an all-cash buyer. So if you have an all-cash buyer, okay, and let's say you're representing the seller and you're waiting for the buyer to release their contingencies. Well, you can release your contingencies one of 3 ways. You can release all of them at once, you can release them one at a time, or you can release them all but, right? Well, invariably, with the all-cash buyer, they release the contingencies one at a time, but they don't check the appraisal contingency. So the agent calls the agent representing the buyer and says, hey, you haven't released your appraisal contingency yet. And the other agent snaps back, this is an all-cash offer. There is no appraisal contingency. Oh, yes, there is. Even with an all-cash offer, there is an appraisal contingency. So make sure if you're representing a seller and it's an all-cash offer, that buyer releases the appraisal contingency. Otherwise, they could cancel right before close based on a last-minute appraisal. And you don't want to be in that situation. Under loan terms, the buyer will deliver to seller that pre-qualification or pre-approval letter within 3 days after acceptance, unless the box under J1 is checked, which means it's attached to the offer. And again, attaching a pre-approval or pre-qualification letter with your offer is going to make your offer stronger. The only difference between pre-qualification or pre-approval is better, but we don't have a better definition other than that, okay? Every lender will tell you a different definition between pre-qualification and pre-approval. There are no set definitions for those terms industry-wide. J2 states that the loan is a contingency, okay? And J3 states that the contingency will be removed within 21 days after acceptance. Now, if any of these dates or days is too short or too long, you can change them. I don't recommend you make them shorter because that's going to be putting a burden on your buyer. Of course, making them longer is better for your buyer, but it's going to make your offer weaker from the seller's perspective. So I recommend going with the pre-printed language. Now, J4 says there is no loan contingency. And what that means is if your buyer cannot get the loan, they'll buy it anyway, which presumably means they have to pay cash. And every now and then I get an agent says, well, my buyer doesn't have the cash. Well, that doesn't matter. If you go with no loan contingency, you are going with buying the property, whether or not you get the loan or not. So be very careful with J4 because it says you're going to buy the property regardless of getting the loan. Now, J5 is really more of a disclosure dealing with what we call lender limits on buyer credits. So to understand this, and this is a lender rule, okay? There's nothing we can do about this. Lenders like 20% down, okay? That's the sweet spot. If you've got 20% down, lender is happy. No PMI, okay? No additional, I mean, no secondary, no, it's sweet. Everybody likes 20% down. If you have more than 20% down, lender is ecstatic. Nothing makes a lender happier than a 35, 40% down, because that's going to be an easy loan. But once you have less than 20% down, now lenders get nervous and they're going to want some kind of a guarantee or insurance because the buyer is coming in with less than 20% down. So let's say hypothetically our buyer is coming in with 20% down. Sweet, right? But let's say back in page 1, the buyer is asking the seller to pay $8,000 in closing costs. Well, the closing costs are only $6,000, which means the seller is going to be rebating back to the buyer an additional $2,000. Well, what's happened to their 20% down? Well, now it's 19.89% down or something, right? Because they're getting cash back. That's going to raise a red flag with the lender. The lender's going to say, no way, this is not a 20% down, because part of that 20% down is actually a rebate back from the seller, which is not illegal, but it violates the lender's loan standards. So what will happen per paragraph J5 is that excess credit goes back to the seller. The purchase price will not be affected. Okay, so that's what we mean by lender limits on buyer credits, or should we say excessive buyer credits. Paragraph K says the buyer is stating this financing is what it is and seller is relying on it. Again, if you come in stating that this is a conventional loan and then in escrow, you say, oh, by the way, didn't I mention we're doing FHA? You're in violation of K. You've made a material misrepresentation. You could be sued. You could lose your license for potential fraud. So again, make sure you're upfront on the type of financing you're trying to get. Now, is it an issue if you come in with a fixed rate and want to go to an adjustable rate? I think you're okay there. But it's a big issue if you go from conventional to government. All right, moving on down, paragraph 4, sale of buyer's property. If the buyer has a property they need to sell before they can buy this property, and they want to make that a contingency, then they would check the box under 4B. If they don't, then they just go with 4A. Now, if you check the box 4B, you're going to have the CAR COP form, or contingent of purchase form, attached. That form will identify the property the buyer is trying to sell, if it is listed, if so, who it's listed with, is it in escrow, who is it in escrow with, and it will also address what happens if the seller gets a second offer. Can they give buyer number 1 a 3-day notice to release the contingency and then go with buyer number 2? Or does buyer number 2 go in as a backup and we still wait for buyer number 1 to perform? Now, the current version of the COP is 1 page. Next month, if it doesn't happen this month, the COP form is going to go to 2 pages. So there's a new COP form out there, just an FYI. It is now going to a 2-page form. I don't know if it's been loaded into zip forms yet, but I did see a sneak preview of it last month at CAR Legal Affairs. Paragraph 5, addenda and advisories. So if any of these apply to the property, you would check those boxes and attach them. Same thing with buyer and seller advisories. You would go ahead and check those and attach them. Now, If under 6, you need more space, under 5A on the right-hand side, you can add the CIR addendum, which is a one-page form that has nothing but lines on it. So you can just alter the contract however you want to. But hopefully the 4 lines there in paragraph 6 will be sufficient. Now, when filling out paragraph 6 or the addendum form, as well as the counteroffer form, we're not going to really talk about the counteroffer today, but the counteroffer form will work the same way. I recommend that you identify the items under paragraph 6 in bulleted fashion. So next to the semicolon, you would write a little a, actually a capital A. Underneath other, B, the next line C, the next line D. In other words, a new line with every point. That makes it real easy for everyone to understand. If you write it in a paragraph, it's hard to figure out what the things are. So here you want to do it in bulleted fashion, 6A, 6B, 6C, 6D. If you need more, then check the box up in 5A, add the addendum page, and you can go crazy with changes. Just remember, the more extensive you modify this contract, the greater the likelihood you're going to enter into the unlicensed practice of law. So just beware of that. You don't want to go there, okay? Hopefully you can confine your remarks to what is found in paragraph 6 if you have to make significant changes at all. Let's go down to paragraph 7A. The first area there, little 1 or bracketed 1, is to specify the NHD or natural hazard zone disclosure report. So in your office, you've got brochures from NHD providers. Your office may have an NHD recommended provider. Talk to your broker or manager if you're not familiar. Those representatives will be happy to come out to your office with just a phone call. They'll probably bring you some donuts or cookies or other goodies, and they'll explain how NHD reports work. The next item, 7A2, is for additional reports as well as 7A3. So if you have a situation, let's say you want to call out for a termite report, all right? You would check the box for seller to pay for the following report, and you would write in termite, or if you wanted to be technical, would destroy pest. Shunlin, you need to mute your mic, okay? Thank you. Going back to 7A2, if you want to have the seller pay for a termite report, you would check the seller box there, and then you would write in the type of report, termite is fine, and then who's going to prepare it. I do not recommend you check buyer for any of these boxes. The reason for that is buyers always seem to have less money than they think they're going to have at closing. If you check the buyer box, while the seller doesn't care if the buyer pays for something or not, they don't care if it gets paid for or not. They don't care if it gets done, right? The seller's selling the property. The buyer's lender may care. So it may show up as a loan condition. So what this contract is trying to do is commit the seller to do certain things, namely sell the property at a certain price, right? So when you're going to allocate the costs, my recommendation is either have the seller pay for it or leave it blank. And then if the buyer wants to pay for that item, they certainly can. Now, under 7A1, most sellers are real good about paying for an NHD report because they are required in most situations, right? If you want to have the seller pay for a termite report, you can put it in there. Some agents will try to make the seller pay for termite repairs. I don't recommend doing that because nobody knows what those repairs will be. Now, they can be as low as $1,000 or less if no tenting is involved. If tenting is involved, they can be between 4,000 and 6,000. It kind of depends on how big the house is. But I have seen termite reports that have come back in the $38,000 and $42,000 range because of damage due to subterranean termites. And getting a seller to commit to pay for something and they don't know what it's going to cost can lead to legal ramifications down the road. And you don't want to be the person that caused those legal ramifications to occur. So my recommendation here is have the seller pay for the report if you want to. Okay? Don't have the seller pay for the report if you don't want to. Remember, most termite companies will come out and do an inspection report for free. So if the buyer just wants to have a termite inspection done, they don't have to put anything here in the contract. Then when the report comes back, if there's infestation, do a request for repairs to the seller. If the seller doesn't agree to repairs, the buyer can say, sorry, no deal. Seller now has to go back on the market, and the next buyer that comes in, the seller's going to have to disclose those termite repairs that have to be done, and that buyer's going to ask the seller to do the repairs. So you can usually get the seller to do the repairs, right? But if the buyer doesn't want to have the repairs done, or maybe the seller won't agree to do the repairs, buyer can still buy the property. And because you did not put under 7A2, identifying that a termite inspection was going to be done, the lender doesn't know there was an inspection done, and the lender probably will not require an inspection report unless you got a government. Sometimes they will require it on an FHA or VA. Now, under 7B, all properties are required to have a smoke alarm, a carbon monoxide device, unless the house is exempt from a carbon monoxide device, and the water heater to be braced. So all houses are required to do that. If your house doesn't have that, then I think you're liable for a $100 fine, okay? But who's going to know, right? Here's where the buyer can ask the seller to pay for the installation of those three items if the property doesn't have it. And then at the top of page 3, some cities, and your government affairs director can tell you which cities those are, but some cities require an inspection prior to close of escrow so that they can see if any items down here under B1 are missing, and they charge for that. So here's where you can have seller pay for that charge. And then finally, under 2 little I, if there are any other required retrofits that have to be done, the most common example here is low flow water devices like toilets and showers. If those have to be done, who will pay for those? And again, 2 little I2 usually kicks in when you have a local government inspection. All right. Now, if the property was built after 1994, the minimum water conservation retrofits fixtures were required as part of the building code. So typically the only time you're going to run into water conservation issues with appliances, shower heads, those kind of things are for houses that were built prior to 1994. And of course, in Arcadia, we have a lot of those houses, right? All right, so let me go up here to see if we have any chats. Nothing in the chat room, so I'm going to continue to move forward. And that brings us down to C, escrow and title. So typically here in Southern California, The buyer and seller split the escrow fee. So you would actually check both boxes under C1A for buyer and seller. And then in that line, I usually write each to pay their own. I know some agents write split 50-50, but it's really not 50-50. It's 50-50 for the sale. But remember, the buyer is also escrowing their loan. If they're getting a loan, there's actually two escrows going on, one between the buyer and the seller, and the other between the buyer as the borrower and their lender. So I think it's cleaner to put under C1 to the right there, each to pay their own. But if you write in there 50-50, we know what you're talking about. And then who the escrow holder is going to be. Now, I know some agents put in seller's choice. I don't like seller's choice because then you still have to agree who the escrow company is going to be. So you representing the buyer, you're typically going to call the agent before you write the offer to say, is the property still available? Or ask, is the property still available? Are there any other offers on the property? And I have a buyer and we're getting ready to write an offer on your property. That's a great time to ask them if they have a favorite escrow company, title company, natural hazard disclosure company, home warranty company. You get the drift, right? Termite company, that sort of thing. Then go ahead and put that in. Have a conversation with your buyer and say, you know, escrow and title should be negotiated between the buyer and the seller. But of course, buyers and sellers don't know what escrow and title does, much less who they are. Oftentimes, agents have favorite companies. And it just so happens that this agent has a favorite escrow company or a favorite title company. And then if you don't have a problem with that company, say, you know, I think they'll do an okay job. But if we put the name of that company in here, that agent will like our offer a little bit more and they might help us get it sold a little bit faster. Okay, so again, you can use that as a negotiating tool. Under C2, who the title policy is. Now here in Southern California, the seller typically pays for the buyer's title insurance or owner's title policy. And then under C2B, the name of that company, who that title company will be. And then we go into other costs. And again, remember, whose name do I like to put in? Seller. So seller will pay for the county transfer tax. Some cities will have a city transfer tax. Again, your government affairs director can tell you who those cities are and how much it is. If the property is in a homeowner association, you can ask the seller to pay for the homeowner association transfer fee. Now you notice under D4, seller will pay for those HOA fees for those documents that are required to be given to the buyer by the seller. That's per Civil Code 4525. All right. Then some homeowner associations have additional documents they provide. So under 5, you can decide who's going to pay for those. But remember, who do I like paying for them? Seller. I just put down seller. And then if seller doesn't like it, they can always counter it out. All right. Under 10, if you want the seller to pay for a home warranty plan, you can specify that there. And again, your office has representatives from home warranty companies who come in, explain the benefits of their service, right? Or if the buyer doesn't want to ask the seller to pay for it, you can check the box at the bottom there where the buyer is waiving the purchase. However, may decide later during the transaction to purchase it, all right? That way, it serves as a disclosure that the buyer was made aware of a home warranty plan. Now, home warranty plans are kind of like insurance policies for appliances. So if the heater breaks down or the stove breaks or something like that, with I think it's up to now a $60 service call, they will come out, repair or replace the appliance. It's a nice thing to get to buyers if they're buying an old home. So if you're buying a relatively new home, say in, I don't know, thinking of a new community, West Covina, maybe Diamond Bar, might not be a big issue. But if it's an older home, say in Arcadia or Pasadena, then particularly if it has original appliances, it might be a good purchase or something to ask the seller to pay for. Okay. Sometimes I know that even agents will actually pay for this, right? All right. So moving on down to 8, and we'll hit in 9, then we'll go ahead and take some questions because I see we've got some stuff in the chat. Paragraph 8 are things to be included or excluded from the sale. Now, 8A says anything included or excluded in the MLS, flyers, or marketing materials are not included unless specified in this paragraph. Beware of that line because judges don't follow it. If something is stated as being included in the MLS, then the seller better include it. If something's stated as excluded, then you better list it here in this paragraph. Whatever is stated as being included or excluded in the MLS or in flyers or marketing materials, you better repeat it here because I've seen many cases go into small claims court where the seller said we're including the refrigerator or the washer and the dryer, but it's never mentioned in the contract. So the seller doesn't include it. They take it with them. But the buyer's got a copy of the MLS saying it's included. The buyer sues, not just the seller, but the agents. And you know what the judge says? The agents represented that the washer and dryer or the refrigerator was included. It wasn't included. That's a misrepresentation, and we'll find the seller and both agents liable because the seller is responsible for what the agents do, and the agents should have known better. They're the professionals. So again, if something is to be included, you need to repeat it here. If something's going to be excluded, you need to repeat it under C. Make sure it's documented on things included and excluded. And things you're not sure about, the gazebo, the above ground spa, the swing set, the storage shed, the barbecue apparatus that they got at the LA County Fair in Pomona, anything like that, specify it in the contract. Then you won't have any misunderstandings, right? So let me go into our chat and see what we have up here. If on the MLS, the agent says seller's choice on escrow and title, can the buyer still request to be an independent escrow company? My recommendation, Jenny, is specify the particular company. So the listing agent is saying you can pick whatever escrow or title company you want. Then my recommendation is you go ahead and specify who you think to be the best escrow company or the best title company, okay? But again, iron it out in the contract. Specify the terms in the contract. That's what it's supposed to be there for, okay? Always a good idea to specify. Okay, so let's go down now to paragraph C. One last point. I'd just like to bring this up because a lot of people miss it. That flat screen in the living room, that's personal property. The seller can take it. The bracket that's mounted in the wall, that's real property. It needs to stay. Unless you check that box at the bottom of paragraph 8C, then the seller can remove the bracket. They have to patch the holes, but they don't have to repaint because that's what the contract says, all right? But my recommendation is have the seller leave the bracket, all right? All right, so now down in paragraph 9A, it states that the buyer is going to live in the property unless the box is checked. Then it's not going to be the buyer's primary residence, which means a little higher interest rate on the loan because lenders give a lower interest rate for buyer's primary residence. Then for seller occupied or vacant property, possession will be given to the buyer at 6 p.m. on the date of close of escrow. Now, you can make that sooner or later. It's never a good idea to have the buyer move in early. It's never a good idea to have the buyer move their stuff in early to the garage. Even though CAR have forms for each of those situations, it's never a good idea. It's never a good idea to have the seller stay later. Although CAR has a form that we're about to see that allows for that. The only time I have ever, in my 40 some odd years of being in real estate, have allowed a seller to stay in the property after close of escrow is when I have an elderly seller, like in their 80s, and I have a buyer that doesn't need possession right away. I might suggest the seller stay in the property for up to 3 days after close. Okay. This can do two things. First of all, it makes the seller a lot happier. Because once sellers get into their 80s, it's not about the money anymore, right? They're in their 80s. They're never going to spend it. It is about convenience. And convenience is more important than money for people in their 80s. So you might get a better price on the property. You might get better terms in other places if you're a little bit more flexible with a seller in their 80s on close of escrow. But I typically never go longer than 3 days. Now, on our next page, okay, top of page 4, seller to remain in possession after close of escrow. So we have two scenarios. Is the seller going to be in the property for less than 30 days or more than 30 days? If it's less than 30 days, you check the first box and you'll attach the SIP, seller in possession. If it's for more than 30 days, you check the second box, and that's the RLAS, residential lease after sale. What's the difference? Well, if you're going out more than 30 days, you have a real landlord-tenant situation, and you might be charging rent, security deposit, etc. If you're less than 30 days, you still have a landlord-tenant situation, but it's a little bit more informal, and that's why you have the two different agreements. Buyers need to remember to contact their insurance company to let them know the seller is going to be in the possession of the property. Insurance company is going to want a copy of either of those agreements, whichever one you're using. And it's going to cost the buyer a little bit more because they're going to have to pay for a writer for that insurance. It could also affect the loan if the seller is going to be in the property longer than 30 days. So the lender is going to be queued into it as well. Now, under D, tenant occupied property. So you have a property with a tenant in there, and the buyer intends to live in the property. It states that the property will be vacant for at least 5 days prior to close of escrow. All right. Why 5 days? Well, that's the time period to do your final walkthrough. We'll get to that in paragraph 15, I think it is. Okay. So when the buyer goes through to do their final walkthrough, they want to make sure the tenant is out. If the tenant's not out, then the buyer needs to contact escrow and say, we need to extend the closing date, and contact their lender and say, we need to extend the funding date. And of course, the lender's going to charge for that, and the seller's going to be liable for that because this contract says that the seller will have the tenant out 5 days prior to close of escrow. Now, let's look at our time frames. Remember, our contingency period is what for inspection? 17 days. Most sellers don't want to give their tenants notice until after the buyer releases their contingencies. So if we use the 17-day contingency for inspection, You have 17 days. After they release their contingencies, now the seller gives the tenant a 30-day notice, assuming it's a month-to-month tenancy. If it's in a lease, then tenant can stay in through the duration of the lease. So you may have to do a cash for keys to get the tenant out. But if it's on a month-to-month, if the property is going to be occupied by the buyer and it's a single dwelling, like a single house or a condo, and you're going to have the transaction escrowed, even if the tenant has been in the property for over a year, you'd only need to give a 30-day notice. I know in most cases, if the tenant's been in the property for over a year, you have to give a 60-day notice, not if the buyer is going to occupy a single dwelling unit, a single family dwelling, all right? But you take the 17 days followed by the 30-day notice, that's 47 days. Now 5 more days, the property needs to be vacant, we're at 52 days. And you need to add on what? Another 4 days for the loan contingency, because the loan contingency is 21 days, right? You're not going to close this thing in less than about 60 days. So just keep that in mind. And my recommendation is when your buyer releases contingencies, ask the listing agent for a copy of that 30-day notice. Because I've seen too many cases where, for whatever reason, the seller or the lender think that tenant is going to vanish in thin air at the end of escrow, and they don't. You've got to give them notice. Now, if the buyer wants to buy this property with a tenant, then they can use the TIP form, tenant to remain in possession. All right. Paragraph 10 are our statutory notices. I do call your attention to 10A4. This is where a seller who has to complete a TDS must also complete the SPQ, Seller Property Questionnaire. It also states that if a seller doesn't have to complete a TDS, like a lender-owned property they got back through foreclosure, which we call an REO, real estate owned, or a probate sale, it states that the seller will do an ESD, an exempt seller disclosure. Now, if you have a seller who has to fill out a TDS and doesn't want to do an SPQ, or if you have a lender who's a seller who's exempt from a TDS but doesn't want to do an ESD, you can counter those out. The SPQ and the ESD are not required by law. They're required by contract. So if the seller wants to counter those out, they can. But a seller who has to complete a TDS cannot get out of that by contract. Civil Code 1102 requires most sellers to complete a TDS. Your exemptions are probate, lender-owned property being sold, or a testamentary transfer. The seller died and it's now being done by a testamentary trust, all right? So those are exempted, but pretty much all other sellers must complete a TDS. Paragraph B informs the buyer of natural and environmental hazard zones and the booklets. Paragraph C talks about withholding taxes. Okay. FIRPTA, Foreign Investment Real Property Tax Act. If the person selling the property is a foreign national. Paragraph D is your disclosure on both Megan's Law, and then E, gas and hazardous liquid transmission lines. And then F, if the property is in a condo or planned development, the seller has 7 days to disclose that it is in one of those developments, and the form to use is the SPQ or the ESD. So we finished up this page. I see I have a question in the chat, so let me access the chat. The question is, what about a seller who bought the property from a court sale or REO? are they exempt from a TDS? And the answer is no. Okay. Just because you bought it from a seller who was exempt, like a lender and an REO, when you go to sell it, unless you are the lender who took the property back through a foreclosure, or you are the executor in a probate, or you are a successor trustee because the seller has died, you are not exempt from a transfer disclosure statement. So in most cases, if you have a living, breathing seller, okay, they have to complete a TDS. Okay, so just about all of your transactions will have a transfer disclosure statement. All right. Okay, our chat room is empty. I will move on to our next paragraph. If I can get my, which is page 5. All right. So if that seller's property is in a condominium or planned development complex, they have to inform the buyer of that within 7 days, but they have to request copies of the CC&Rs within 3 days. So in my book, it's not a bad idea for the seller to go ahead and order the CC&Rs. With most of your larger associations, they're all done online. You just use your credit card number and they email it to you and you got it, okay? Now go to paragraph 11, condition of property. So the seller is selling the property in its present physical condition or as is, all right? So what that means is the seller is under no obligation to make any repairs. However, anything the seller knows that could affect the value of the property, we call these material facts and defects. They must disclose it to the buyer. So the seller has an obligation to disclose, but the seller does not have an obligation to repair unless they agree to do so. And the seller does not have an obligation to investigate their property. So I don't recommend sellers investigating their property. I don't recommend sellers hiring a physical inspector to inspect their property. If the seller's never lived in the property and they're worried about things that might be wrong with the property, have them offer to pay for the buyer's physical inspector up to $400 or $500 or whatever. You see, if the seller does their own inspection and they give that to the buyer and that inspection has a mistake, now the buyer may sue them for giving them a bad inspection report, right? So it's better for the seller to offer to pay for the buyer's inspection report. And then it's the buyer's fault they picked the bad inspector, right? Paragraph 12 tells the buyer they are obligated to investigate and inspect their property. They have an obligation to do that. Paragraph 13, how the buyer takes title is something they should converse with their attorney or their CPA, because there are legal and tax consequences. Do not even share how you take title to your own home, right? If you want to give them something, most of your title companies will have those nifty little charts that shows the different ways of holding title in California: tenants in common, joint tenancy, community property with right of survivorship, right? You can give them that, right? But don't make any recommendations. All right, so let me see what we've got in the chat here. Got a couple of chats coming in. I'll take care of those now. All right, let's see. What about the seller who bought the property quarter? Yes. What if the buyer is an LLC who bought the property from a court sale? LLCs are not exempt from TDSs, nor are corporations. So corporations, partnerships, general or limited partnerships, LLCs, not exempt. The easiest way to know about an exemption from a TDS: if somebody died then you may have an exemption of TDS. If the seller's the lender, you probably have an exemption from a TDS. So death and lenders, those are the two, okay? There's one other, it's the irrevocable trust. And the reason you'll know it's an irrevocable trust is the trustee is an attorney or a bank. So here they are: death, right? Lender, bank, attorney. If one of those are signing the documents as the seller, then you may be exempt from a TDS. But that's it, okay? That's it. Other than that, you're going to have a seller doing a TDS. So request a CC&R. Usually, does the listing agent need to request it in escrow, or will escrow order it? Well, escrow typically will not order it because they can't pay for it. The seller has to pay for it. So the seller will need to advance funds to escrow so escrow can pay for it. You can't pay for it out of the buyer's deposit because the buyer's deposit is refundable to the buyer if the buyer cancels within their contingency period, right? So you've got to watch out for that. So the best way is to have the seller go on to the site if they're computerized and have the seller pay for it, okay? That's the easiest way to do that. I know back in the old days we had escrow do it, but it doesn't work very well that way, all right? Okay, moving on to page 6. Here are time periods, removal of contingencies, and cancellation rights. So let me take this as simply as I can, okay? Hold on for a second. I hear something. Nothing to worry about. All right, so for time periods, the seller has 7 days to remove all contingencies. Whatever, sorry, let me back up. The seller has 7 days to make all disclosures. So anything that could affect the value of the property, any reports the seller has, transfer disclosure statement, all of that, the seller has 7 days to turn all that stuff over to the buyer. I would also add here that the agents in the transaction representing the seller and the buyer should give their AVID, their agent's visual inspection disclosure, to the buyer in those 7 days as well. Because the AVID is referenced in the TDS. Since the seller has to give the TDS within 7 days, my feeling is the agent should give their AVIDs within 7 days. All right, so that's from date of acceptance. The buyer has 17 days from the date of acceptance to review those disclosures, to investigate the property, to do any inspections on the property. All right, so the 7 days and the 17 days run at the same time. It's from the date of acceptance. Now, on or before the 17th day, the buyer is supposed to release their contingencies. If they don't, then the seller must give a notice to buyer to perform. It is a 2-day notice, and it can be given 2 days early. So the buyer, let me back up here. The seller can give the buyer that 2-day notice to perform as early as the 15th day from acceptance, or as late as they want to. Now, if you have a situation where you're representing the seller and the buyer hasn't released their contingencies, I always encourage you to contact the other agent and ask how the investigation is going. Let them know that that 2-day notice is coming, all right? For some reason, agents get their nose bent out of shape if you just give them a notice to perform. They shouldn't, because the buyer is supposed to release the contingencies without being reminded. But we want to keep peace in the transaction. So let the buyer know, or to me, let the agent representing the buyer know that they're going to be getting a notice to perform. You might want to just call the agent up and say, how's the buyer doing with their inspections? Well, they're still kind of looking around. Well, you know, it's been 15 days and the seller wants to keep things moving on. So we're going to be sending over a notice to perform. The agent might say, well, that's kind of rude, isn't it? No, it's not rude. You're supposed to release the contingencies without being asked. Now, if the buyer doesn't release their contingencies, the seller's remedy is to give that 2-day notice to perform. After the seller gives the 2-day notice to perform, if the buyer still doesn't release their contingencies after the 2 days, then the seller can cancel. But the seller doesn't have to cancel. But the seller can't cancel unless they give that 2-day notice. So if you're representing a seller, when you're coming up to that 17th day, call the other agent, find out what's going on, protect your seller, give that 2-day notice. So if the seller wants to cancel, they can. Remember, the seller cannot cancel unless they first give that 2-day notice and then wait those 2 days. So if you wait until day 20, then the seller can't cancel until after day 22. So that's why it's important to give that notice on or after the 15th day. You need to keep this thing moving along, all right? Now, if the buyer does not release their contingency, the contingency continues. It doesn't automatically terminate, right? So if we're on day 25, day 30, and the buyer has not released their contingency, do they still have it? And the answer is yes. Well, what about if the seller is given the 2-day notice? Then the seller can cancel, but the buyer still has not released their contingency, which means the buyer can cancel. The buyer can cancel without any penalty as long as they have not released their contingencies in writing. So that's paragraph B4. The contingency continues until the buyer releases it. Now, what if the buyer releases their contingencies and the seller gives a late disclosure? The seller forgot to disclose something and they give a late disclosure on day 25. Well, under paragraph 14B3, the buyer now has a new 5-day period to remove contingencies. So a late disclosure by the seller will recreate or extend the buyer's contingency period. Now, under 14C, the buyer may remove their contingencies with the offer, which means the buyer has no contingencies. That's kind of scary, okay? So you better make sure that your buyer is sophisticated enough to understand that they're going to be buying this property essentially sight unseen. The other things to remember is during the buyer's inspection period, the 17 days, the seller needs to keep the utilities on, okay? Seller needs to keep the utilities on, and the seller needs to allow buyer access. And I realize that sometimes buyers like to come in 2 or 3 times. Seller needs to allow that to happen during those 17 days, right? Now, D talks about the seller's right to cancel. Again, seller cannot cancel unless they first give that 2-day notice, all right? Once they give that 2-day notice, the 2 days run, then if seller wants to cancel, they can, but they don't have to. Last point. When we get down to close of escrow, that's now on G. So we've already taken care of the contingencies. They've been released by the buyer, okay? They've been removed. But for whatever reason, the buyer's not following through. and we come up to the date of close and the loan hasn't funded. And the seller says, let's cancel this thing. Hold it. Before you cancel at the time of close of escrow, seller must give the buyer a 3-day notice, demand to close escrow, the DCE. Okay? Basically, you're giving the buyer an additional 3 days to try to get their act together. Okay? So that's at the close of escrow. Buyer, for some reason, can't perform that. Okay? So it's separate and apart from the contingency. Why they put it in the same paragraph, I don't know. Wish they hadn't, because people want to confuse the two. They're separate. Cancellation, effective cancellation on deposits. Remember, unless the buyer has initialed the liquidated damages clause, okay, the deposit is refundable. The deposit is always refundable if the buyer hasn't released their contingencies. So the only way the seller can keep the buyer's deposit is if the buyer releases contingencies, then does not perform, and has initialed the liquidated damages clause. If all three are in play, then the seller has a claim to the deposit. You'll notice the last line in bold at the bottom of H says that if a party does not release the deposit without a good faith reason for refusing to do so, they can be liable for an additional civil penalty of $1,000. Okay. And that takes us up to page 7. So let's see, we've got a chat. Okay. Does rescission right apply to amendment to seller's disclosure? This amendment is to capture a newly discovered property condition. Okay. So the buyer is to release their contingencies after the 17th day. If they're still making inspections, they shouldn't release that contingency. They should ask for more time. Once they release their contingency, if the buyer now discovers something new wrong with the property, they don't have a right to cancel unless they think they can prove that the seller was hiding it. That would be their only possible action, right? And that's going to be kind of difficult to prove. Now, if the seller gives a late disclosure, let's say the buyer releases their contingencies on day 17, and on day 25, the seller says, oh gosh, I forgot to tell them about the unpermitted room addition. And they disclose to the buyer they have an unpermitted room addition. Buyer has 5 more days of contingency. So on the 30th day, or 2 days before, the seller could then give a new notice to buyer to perform, in other words, to release that contingency. But if the buyer discovers a defect in the property after they've concluded their inspections, after they've released all contingencies, that does not give them a right to rescind unless they want to try to allege that the seller was actually hiding the item. And that's going to be rather difficult to prove. All right. Okay, so let's move on to page 7. Paragraph 15 is our final verification of condition. Excuse me while I get some tea. This is our final walkthrough that's done 5 days prior to close. Paragraph 16, all repairs are to be done if they have been agreed to be done. So again, sometimes the buyer during their inspection period will request repairs done by the seller. If the seller agrees to do the repairs, they need to show paid invoices on those repairs. So the buyer knows not only that the repairs were done, but they were paid for. Paragraph 17, prorations on property taxes and other items. So this is an allocation of income and expenses based on the date of closing. So property taxes are often prorated. If you're buying a rental house and you're closing on the 15th of the month, the seller's probably collected the rent, right? But you're entitled to the second half month's rent because that's the period of time you're going to own the property. So what escrow is going to do is they're going to debit or release, or debit or lower the amount of money the buyer has to pay for the property based on that half month's rent. That's called a proration, okay? So interest if you're taking over a loan, property taxes, rents, insurance, those can all be prorated. Paragraph 18 speaks that the brokers are not a party to this agreement, but are being compensated per a different agreement. Oh, by the way, if you're representing a buyer and you're writing an offer on a for sale by owner, do not put your commission in this agreement because you're not a party to this agreement and it's unenforceable. Because in order to have an enforceable commission agreement in a residential transaction, you have to have in 10-point bold type a notice that commissions are negotiable. So before you write an offer on a for sale by owner, make sure that that for sale by owner signs a single party compensation agreement. CAR has the form. It's called the SP form, Sam Paul Single Party Compensation Agreement. Once they sign that, then you can present your offer for your commission. All right. Paragraph 19, representative capacity. If you're representing an LLC, corporation, a trust, you don't have enough signature lines, particularly if you're going to be doing a paperless transaction. So you need to add the RCSD or the RC, what's the other one? BD for the parties, okay? Representative capacity. And then paragraph 20, the joint escrow instructions to escrow holder. This tells escrow what paragraphs she needs to be concerned with, or he if you have a male escrow officer, although most escrow officers seem to be female. Okay, I think I saw something else in the chat room, so let me look at that. Okay, what is your opinion on a realtor actor as a power of attorney? Absolutely not. Way too much liability. You never want to have a power of attorney for your client. The only exception is if that client is a family member and you already have a power of attorney on them because you are their next of kin, you are their child, you are already acting for them. But you never want to have a power of attorney because that actually gives you the right to sign documents on their behalf. Tremendous amount of liability and risk. Talk to your broker. Your broker will tell you absolutely not. So again, don't ever take a power of attorney for a client. You're just asking for all kinds of horrible liability issues. All right, let's move on. Paragraph, page 8. Now we get to paragraph 21. And paragraph 21 deals with the liquidated damages clause. Now, 21A basically says that there is no such thing as a non-refundable deposit, okay? So please do not ever write non-refundable deposit, because the only thing worse than the unlicensed practice of law is the unlicensed practice of the wrong law. So again, it is instant malpractice to write non-refundable deposit. Don't do that, right? Paragraph 21B, if initial, means that if the buyer breaches this agreement, the seller is entitled to keep the deposit. However, if the deposit exceeds 3% of the purchase price and the buyer was going to live in the property, then the amount of money the seller can keep is capped at 3%. Okay. It doesn't say that the liquidated damages are 3%. No, the liquidated damages are the amount of the deposit. However, the buyer's going to live in the property and the deposit exceeds 3%, then the amount of money the seller can keep is capped at 3%. So that's what that says. All right. So again, don't ever call it a non-refundable deposit. It's liquidated damages. Okay. And the way the clause works is buyer releases their deposit, buyer releases their contingencies. Buyer then is unable to perform. And if the seller and buyer have both initialed here, then the seller can keep the deposit. Well, what if one party initials and the other party doesn't? You don't have a contract. Whether it's in this paragraph 21 or in the arbitration paragraph, if one party initials a clause and the other party doesn't initial a clause, you do not have a contract. So what I used to do when my buyer was doing, say, liquidated damages or arbitration clause, if they initialed, I'd take my highlighter and I would actually highlight the word seller's initials. And I had one agent tell me, "You're trying to get the seller to do that." And I go, "You're darn right I am." They will either initial it or they're going to counter it out. Because if they don't do one of those two things, we won't have an enforceable contract. So that's very important that you make sure that's addressed. Okay, going to paragraph 9. Did I just lose my, no, I didn't. Okay. Paragraph 23, selection of service providers. Okay. Escrow, title, termite, home warranty. We don't guarantee their performance. The choice of those providers is the buyer or seller. And it's important to remember, I see agents that exert way too much pressure on a party to go with a certain service provider. And that raises the issue of a RESPA violation. Why are you so committed to a certain title company, escrow company, home warranty company, whoever, unless you're getting compensated? That's called a kickback. That is illegal under federal law. So you want to be very careful about that. We recommend, we don't insist. It's a buyer and seller's decision of who they select. All right. Paragraph 24, this sale will be put into the multiple listing service. Now, if you're representing the buyer after escrow closes, it's the listing agent that's supposed to enter the names of the two agents in the transaction. It's very important that you look in there and make sure you were entered in as representing the buyer. Unfortunately, there are some agents, listing agents, that will list themselves on both sides. Why do they do that? Well, not that you would ever want to leave your broker. I'm sure you're very happy with your broker, but things happen, right? Including sometimes where companies will close down because the broker retires. So now you have to go to another company. And then during the interview, they will ask you, they always ask this question, how many transactions did you do last year? They already know. They've gone into the MLS and they've looked you up. They just want to see if you lie or not, right? Well, here's the problem. You might have done 8 or 12 transactions last year, but if you were representing the buyer, the agent representing the seller didn't put you down, you're not going to get credit for that, right? So you need to make sure you get credit. So if you see that you weren't put down, call the agent up in a very nice way. Say, hey, I was looking at our transaction and it looks like you put yourself on both sides. They might say something, oh, did I do that? I make a mistake now. No, we know what you were trying to do. You're trying to get credit from my side of the transaction. Don't let them do that. Now, some of you might be working for teams. And it's not unusual in a team or a group that the team leader gets credit for all the transactions. Everything's done under their number, right? Here's what you need to do. At close of escrow, get a copy of the closing statement that escrow provides, right? Showing you were involved in that transaction. Keep a record of those. Should you ever be entering with another broker and they ask you how many transactions, you can say, well, last year I was involved in 12 transactions. However, I was part of the ABC team and everything was reported under our team leader. Here is a copy of the 12 closing statements of those transactions I was involved in, because brokers will put you on a commission schedule based on your transactions, even if it was from an earlier broker. If you did 12 transactions last year, you're probably going to do 12 transactions this year. If you did 25 transactions last year, probably going to do 25 transactions this year. Okay, it's usually pretty consistent. Paragraph 25, attorney's fees will be awarded to the prevailing party, provided they agree to mediation. We'll talk about mediation a little bit. Paragraph 26, I've already talked about. That's our prohibition on assignment without seller's permission. Paragraph 27, we will comply with fair housing laws. Paragraph 28 and 29, this is the entire contract between the parties. There are no other agreements. Time is of the essence, and this contract can only be changed if done in writing and signed by both parties. Paragraph 30 is our definitions. Okay, this is our definitions. Important to remember that days always remain calendar days. Okay, days after, tomorrow is always day one. Okay, so whatever happens today, remember our time starts tomorrow. Tomorrow is day one. Now let me go back. It looks like I skipped over the arbitration clause. I didn't mean to do that. And the mediation clause. Paragraph 22A is a part of the agreement. Parties are required to mediate their disputes. Okay. If you fail to mediate your dispute, you give up your right to attorney's fees. So mediation is required if there's a dispute between the buyer and the seller. Paragraph 22B is arbitration. The parties have to initial at the bottom to include this paragraph. And if they do, then they are giving up their right to trial. And if they have a dispute, it will be arbitrated by an arbitrator. The arbitrator must be a retired judge or an attorney having at least 5 years of residential real estate law experience. All right. Okay, so that concludes the definitions. And then you'll notice in paragraph 31, after this is signed by the buyer, the seller will have up to 3 days to accept. And that period of time can be shortened or lengthened, but you'll find in all CIR contracts, they typically give the other party up to 3 days, okay? And let's go into my chat room. And let's see. If one of the parties does not initial on paragraph 21, is it an executed contract? No. If one party initials either the arbitration clause or the liquidated damages clause, and the other party does not initial it, you do not have a contract. It is the same as if a party didn't sign the agreement. You see, we don't know. One party wants the clause in, but since the other party didn't initial, they want the clause out. At least that's how the law is going to view it, which means you have no contract. Okay? There is no contract. So it's really important. If one party initials, the other party has to also initial or counter it out. Let's see, what is the cutoff time of a day, 5 p.m. or 11:59 p.m.? It's going to be 11:59 p.m. I don't think we use 5 p.m. anywhere in the contract. 6 p.m. is the time that the seller must give possession to the buyer. So at close of escrow, the buyer has the right to occupy the property at 6 p.m. But in terms of days, the day ends at 11:59 p.m. So if I'm giving you 3 days to accept, then after the end of the 3rd day, tomorrow is day 1, day 2, day 3, then at 12:01 on day 4, there has been the cutoff time. I hope that explains it. So again, days mean calendar days, but you'll never find days specified in terms of performance. It's always days after, okay? So tomorrow is always going to be day 1. No matter what happens. So if I give you a notice at 8 o'clock this morning or at 6 o'clock tonight, tomorrow is always day 1. So just remember, tomorrow is day 1. All right. All right. So let's wrap up the last page. The seller now has presumably 3 days to accept, which they would do by signing, or if they check the box, they are going to sign this, but attach a counteroffer. And remember, the counteroffer says that all the terms of this offer are accepted except for these changes. So in the counteroffer, you only list the changes, right? If you need more signature lines, then the seller would attach the RCSD S for the seller, RCSB for the buyer, okay, if you need additional signature lines because you're in a representative capacity. The last couple of things I want to talk about are not required, but recommended. This first paragraph here where you have the initials, what's the purpose of confirmation of acceptance? Let me give you an example. Let's say I write an offer on your listing and your seller accepts. Do we have a contract? No, because you still have to communicate that acceptance back to my buyer or me. Now I say my buyer or me. Me, if my name is put in this second line in 31, I could write my name there, Ed Estes, which means you can communicate acceptance back to my buyer or directly to me. The reason I put my name on that line is I want you to communicate with me. I don't want you talking to my buyer, right? So I recommend you put your individual name there on paragraph 31 on that right-hand side. So you communicate the acceptance back to me, but you don't know if I've gotten it or not. So what I would do, being a good agent, either I would initial, if my name was back on paragraph 31, or my buyer would initial there in initials, and we would write down the date, November 13, 2020, at, what are we, 10:55 a.m. All right. And then I'd send this page back to you. What does that mean? Well, you know that communication has now occurred. You know we have a deal. The buyer and the seller have now entered into a deal, but more importantly, tomorrow is day one. Now, I said this paragraph isn't required. So if you have a situation where the agent's not using this paragraph, I recommend you send an email. Please don't use a text. Send an email to the other agent and say, did your buyer receive the acceptance? And they would sign back, yes, they did. Thank you. And then you can email back, great. Tomorrow is day one for our timeframes. And they might email back, yeah, so what? What's the big deal? I'll tell you what the big deal is. When we're putting a deal together today, it's very easy for us to agree that tomorrow is day one. However, 15 or 16 days from now, when it's time for the buyer to release their contingencies, we're going to be arguing like alley cats over when the 17th day is, right? But if we agree now when day one is, you can put your time frames for day 3, day 5, day 7, day 17, day 21, so we can have all of our dates in our Google Calendar or whatever it is you use, so you don't miss a deadline, all right? So again, if you don't use this paragraph, but that's what it's for, have a communication with the other agent and establish when day one is. Information for the brokers goes here. Information for the escrow goes there. And then at the very bottom, presentation of the offer. So Article 1, Standard of Practice 1.7 of the Code of Ethics now says, if the buyer's broker makes a written request, the seller's broker will confirm that the offer was actually presented to the seller. That's where you do that. But the more important one, I think, is the next and last paragraph, rejection of the offer. What I would recommend as part of your practice is when you present, or let's say you're representing a seller, and an offer comes in, and your seller looks at it and says, garbage, I don't even want to counter it. Have them initial down here, rejection of offer, and put in the date. Then you can send this back to the agent and say, you know, I'm sorry, but the seller just didn't like your offer and I couldn't get him to counter. Now, that other agent's not going to be real happy, but at least they know you presented the offer. This is more critical if you have a multiple offer situation. Here's the situation. You're writing an offer on my listing, and so are 2 other agents. And you're wondering if I even presented your offer, particularly with one of those agents is somebody that works in my office that I play golf with once or twice a week, right? So here's what I recommend you do. I would call each of you back and I would say, hey, got your offer. Thank you very much. I wanted to let you know we're now in a multiple offer situation in case you wanted to strengthen your offer. It's a nice way of saying, if you want to get your buyer to increase the price, I'll wait an hour or 2 for you to do that. And then I'll go one step further. I'll say, because we're in a multiple offer situation, one of the offers is coming from somebody in our office. I wanted to give you and everyone else an opportunity to present your offer directly to the seller and myself tonight. I have a 5 o'clock time, I have a 5:45 time, and I have a 6:30 time. And I'm giving everybody an opportunity to present their offers directly to the seller and myself. Would you like to do that? Now, the nice thing about that is nobody can sell, hopefully, their buyer better than they can, right? Because they're going to get the commission if they're successful. So now the seller has the benefit of an agent who's very familiar with the buyer and of the offer. And if you have one of those situations where the agent wrote a crappy offer, Not that it was a low price, it's just they don't know how to write very well. You can ask them questions to clarify terms of the offer. That's always nice to get. And if my seller decides to go with the other agent, and I let you know that by having my seller sign down here, okay, so you're not real happy, your offer didn't get presented, you're not going to get your commission. But at least you know I gave you every opportunity to get your offer signed, right? So 2 months from now, when I'm writing an offer on your listing, hopefully you'll treat me well as well. Okay, you're going to treat me fairly. So I strongly recommend that just to keep things peaceful in transactions. That is the end of the contract. I don't have anything in the chat room. If anybody would like to unmute themselves, you can certainly give me a verbal question, or if you want to shoot me another chat on any question you might have about this agreement, I'm welcome to take it. If you're shy about using the chat, or you don't want to disclose yourself, there's my email, eestes@mountsac.edu. Don't call me. Our campus is closed due to COVID. All of our classes are done remotely online right now. So I'm not checking my phone messages, but I do check my email messages because I am teaching online. I can't give you legal advice, but if you do have a question about a form or how a form works or anything like that, welcome to help you. Again, don't take any clients, but I can refer you to attorneys who are taking clients. Let's see, I've got something that came into the chat. Can you talk about what is needed to write an offer with no contingencies? Okay, so if you write an offer and you check that box that says no contingencies, that means the buyer is buying that property regardless of the condition. They don't have that 17 days to back out. The seller still needs to provide all of their disclosures. So seller still provides their TDS, their SBQ, you still do your ABID, but I don't care how crappy that house is, the buyer can't cancel. They've got to buy that piece of crap, no matter how bad it is. So seller, go ahead and disclose how nasty it is. The buyer's buying the property with no contingencies. They have no right to cancel. They have no right to back out. They have no right to get out of the agreement. The only thing that might give them an action is if the seller failed to make a disclosure, okay? But the seller still needs to make all of their disclosures. Any other questions? Not seeing anything. So since no other questions are there, Stephanie has already logged out, so it's just me. I'll go ahead and end our class. But again, if you have any questions, oh, got another one coming in. Thought if I talk long enough, somebody might pop up again. Let me get in here and get over here. Oops. It's not easy to open the chat when I've got a PowerPoint open. Okay, regarding the 2 days notice by seller, if everything was okayed by the buyer, in other words, no excuse by the buyer, can the buyer still get out of the contract? The buyer does not need a reason in this contract to cancel during those 17 days. So let me put a caveat there. The reason to get out of the agreement for the buyer is after reviewing the property, they decided they didn't want the property. In other words, presumably they saw something in the property that they didn't like. It could be the color of the walls. It could be the type of carpet. It could be the outside paint of the house. It doesn't need to be a good reason, but it does need to relate to the property. Conversely, if you have a buyer that makes 3 offers on 3 different properties and puts all 3 properties in escrow and then decides one of the properties is what they want, but they had no intention of buying the other 2 properties, that probably wouldn't be a valid reason. But as long as the buyer has decided, you know, I've changed my mind, I just don't want this property anymore because I just decided I don't like it, they can back up. They don't need a reason. Now, that may be changing with the new purchase agreement that's supposed to come out next January, or excuse me, next December. Not next month, but next year. So in December 2021, we're supposed to get a new purchase agreement. And yes, we will have classes here at Arcadia, and I will probably be teaching at least some of them. But in that agreement, I believe there's going to be language that says that the buyer needs to give a reason. We'll see how it goes because that contract has not been written yet, but I have been seeing drafts of it. All right. Any other questions out there?
I have a question,
Sure.
Edwin. When you put in the, where you put in the area where you want the seller to pay most of everything, and you mentioned, we don't have to put the wood destroying there. Do you
Right.
also not put that the buyer will pay for the inspection?
Right, because you don't want, typically here's how it works. Either you want the seller to pay for it or you don't want the seller to pay for it. You can always have the buyer pay for it. But the reason you don't want to have the buyer in the contract pay for it, because then the lender, as a loan condition, might make the buyer pay for a home warranty plan or something else. So you don't have the seller pay for it. And in the case of termite, you can usually find a good termite company that will inspect for free. Since it was never mentioned in the contract, the lender doesn't know about it. Now, if there's termites, the buyer can still do a request for repairs and ask the seller to pay for termite work. If the seller says no, the buyer can cancel, which means the seller has to put the property back on the market and disclose to the next buyer that the property has termites, and that next buyer will probably ask the seller to pay for the repair work, right? So we can negotiate and pressure the seller to do the work. But let's say the seller says, no, I'm going to be nasty and I'm just not going to pay for the work. Well, if the first buyer still wants to buy the property and not have the termite work done, they could do so because their lender doesn't know that there was a termite inspection done on the property because it was never mentioned in the contract.
Okay, so you can basically have, so you can basically have any type of inspection done and it does not need to be written in that area because you have those 70 days in that paragraph that specify you can do, that's your due diligence.
Right. The only reason to mention an inspection in the contract is because you want the seller to pay for it. If the seller's not going to pay for it, either the buyer's going to get it done for free or the buyer's going to pay for it, keep it out of the contract because now the lender won't find out about it because it's not in the contract. And the buyer's under no obligation to disclose anything to the lender, nor is the seller. See, you do not, the buyer does not have a fiduciary obligation of disclosure or any obligation to disclosure to their lender. They don't have that obligation. So the buyer can make whatever inspections they want. They don't have to tell the lender any of that. And then they'll make their own decision whether they want to buy the property, or they can do a request for repairs and ask the seller to pay for it during the negotiations of that 17 days, and the buyer's lender still doesn't know about it because it was never put in the contract, because the lender only gets a copy of the contract. Does that make sense, Edna?
Yeah, makes sense. Thank you so much. Yeah, I like that better than the way usually they teach you to put in, wood destroying and then the inspections, but I
See,
like
and
that better.
unfortunately, some agents will write in the contract to ask the seller to pay for repair work. And the problem with that is you don't know how much it's going to cost. And if it costs a lot, now the seller is contractually obligated to pay for it. And they may not have enough money to pay for it because there's not enough equity. And now the seller gets sued by the buyer. And then the seller turns around and sues their agent for allowing that language to be put into the contract. So you don't want to specify seller paying for repairs. It's okay to ask the seller to provide a credit. And it's okay to ask a seller with a request for repairs when you're in escrow. Just don't put it in the purchase agreement, because you don't know what it's going to cost yet. And that's where you get into problems. Okay. So Jenny has another question regarding first escrow. Buyer did a physical inspection, then escrow canceled. In a second escrow, buyer received this inspection report and waived the physical inspection. If the defect was found later because it wasn't mentioned in the report, is the seller at fault? No, because the inspection was done by buyer one's inspector, and the law requires the seller to give a copy of all inspections to the second buyer. So the seller cannot be held liable for passing on information from a third party that the law requires the seller to pass on. If the law requires you to do something, you have to do it. For example, if you inspect a seller's home representing your buyer for your AVID, right? You're doing your visual inspection, and you find all kinds of problems with the property, and you put them on the AVID, and you give it to the seller for their signature, and you give it to the buyer. Can the seller sue you for saying derogatory things about their house? No, because the law requires you to do a visual inspection. And if you see crappy things with the house, you got to write the crappy things down on your inspection disclosure, right? So no, you're not, seller's not liable. And in that case, you wouldn't be liable for any type of defamation. Okay, termite report to be paid by the seller. However, if there's work to be done, does the buyer have the right to ask the seller to repair after receiving the report? The buyer has the right to ask the seller, regardless if it was put in the contract or not. All right? I have a buyer. I don't put anything in the contract. I don't talk about a termite inspection. I don't talk about a roof inspection. I don't talk about a plumbing inspection. My buyer inspects the property, or I inspect, whatever. We have inspectors go out and we find plumbing problems, we find roof problems, and we have termite problems. So the buyer does a request for repair, right? And says, look, got to get rid of the termites, got to fix the roof, got to fix the plumbing. I have the right to make that request for repairs. Now, the seller has the right to ignore it. They have the right to say no. They have the right to pay for some of it, not all of it. They have the right to say, we'll give you X amount of dollars if you buy the property anyway, we're not going to make any repairs. So you have this little new negotiation during that 17-day period. Any other questions? Okay. Thank you very much. we will go ahead and conclude now. I will take it off here. Thank you all very much. And if you know of anybody who's thinking about getting a real estate license, keep Mount SAC in mind. You'll learn more in real estate principles from me than you're going to learn from a home study school. Bye-bye. Thank you very much.
Thank you.